Scope and nature of the right to freedom of religion in India. The right to freedom of religion in India is a fundamental right guaranteed under Part 3 of the Constitution of India. It is enshrined under Articles 25 to 28 of the Constitution, and it protects the freedom of individuals to profess, practice, and propagate their religion. These provisions aim to maintain a balance between individual religious freedom and the state's ability to regulate religion for the greater public good. The right to freedom of religion is an essential feature of a secular democracy, ensuring that citizens have the right to follow and practice any religion of their choice without fear of coercion or discrimination. However, like other fundamental rights, the right to freedom of religion is not absolute and can be subject to reasonable restrictions in certain cases. Key provisions of the right to freedom of religion. 1. Article 25. Freedom of conscience and free profession, practice, and propagation of religion. Every person has the right to freedom of conscience and the right to profess, practice, and propagate their religion. This article guarantees the freedom of individuals to practice and spread their religion, but it allows the state to regulate activities related to religious practices in the interest of public order, morality, and health. 2. Article 26. Freedom to manage religious affairs. Religious denominations or groups have the right to establish, maintain, and manage religious institutions. This includes the right to manage their affairs in matters of religion, subject to public order, morality, and health. 3. Article 27. Freedom from payment of taxes for promotion of any religion. No person shall be compelled to pay taxes that are specifically used for promoting any particular religion or religious institution. 4. Article 28. Freedom from religious instruction in certain educational institutions. No religious instruction shall be provided in any educational institution wholly maintained out of state funds. Scope and nature of the right to freedom of religion. The right to freedom of religion is a composite right that includes freedom of conscience, the right to hold beliefs and opinions on religious matters, right to propagate, the right to spread one's religion to others, either through speech, writing, or other means, subject to reasonable restrictions, right to practice, the right to engage in religious practices and observances, such as worship, rituals, and ceremonies. The right to freedom of religion guarantees an individual's personal and communal right to practice religion, while ensuring that such practices do not infringe upon public order, health, or morality. It also protects religious communities' right to manage their religious affairs, institutions, and practices without undue interference by the state. Limitations and restrictions. The right to freedom of religion, while expansive, is not absolute. Article 25(2) allows the state to regulate or restrict religious practices that infringe on public order, morality, and health, are not consistent with public policy, or violate constitutional principles like equality and non-discrimination. Thus, while the state respects individual freedom of religion, it can intervene when practices harm public welfare or contradict constitutional values. Important decided cases. 1. State of Bihar versus Miss Annie Besant, 1914. In this case, the Privy Council observed that religious freedom is fundamental and that no law can restrict an individual from practicing and professing their religion unless it violates public order, morality, or health. This case clarified that the practice of religion should not adversely affect public order, and that the state could regulate religious activities to maintain societal harmony. 2. The Commissioner, Hindu Religious Endowments versus Sri Lakshmindra, Tirtha Swamiyar of Sri Shirur Mutt, 1954. This case is a landmark judgment where the Supreme Court of India held that the freedom to practice religion under Article 25 is subject to the law of the land, particularly when it concerns religious practices that are inconsistent with public morality or order. The court ruled that state intervention is permissible in religious matters if it pertains to public order, morality, or health, thus recognizing the limitations on religious freedom. 3. Durga Committee, Ajmer vs. Syed Hussain Ali, 1961. The Supreme Court emphasized that Article 26 grants religious denominations the right to manage their own affairs in matters of religion. However, The court also held that this right is not absolute and can be regulated by the state, especially when it concerns issues of public interest and social justice. The court also affirmed that the state can intervene to safeguard public order, morality, and health. 4. Indian Young Lawyers Association versus State of Kerala, 2018, Sabarimala case. The Sabarimala case is a landmark decision where the Supreme Court of India held that the prohibition on women of a certain age, 10-50 years, entering the Sabarimala temple violated the right to equality and the right to freedom of religion guaranteed under Article 25. The court ruled that gender discrimination in religious practices is unconstitutional, as the right to practice religion cannot violate fundamental rights such as equality and non-discrimination. This judgment highlighted the tension between individual rights and religious practices and the need to strike a balance that aligns with constitutional principles. 5. Rajbali versus Union of India, 1962. This case dealt with the right of a group to propagate its religion under Article 25. The Supreme Court ruled that while individuals have the right to propagate their religion, such propagation cannot coerce others into joining a particular religion and must be done peacefully and in a manner that does not disturb public order. 6. Shah Bano case, 1985. The Shah Bano case revolved around a Muslim woman's right to alimony under the Muslim Women Protection of Rights on Divorce Act, 1986. The Supreme Court ruled that the right to maintenance for a woman, regardless of religion, is a matter of justice and personal dignity, thus ensuring the right of religious freedom does not override other constitutional guarantees. The case led to a national debate on the balance between religious personal law and fundamental rights, particularly in matters of gender justice. 7. R. P. Luthra versus Union of India, 1974. In this case, the Supreme Court observed that the right to freedom of religion includes not only the right to practice and propagate one's religion, but also to manage religious institutions without interference from the state unless public order is threatened. The court stated that religious institutions can be subjected to reasonable restrictions imposed by the state for the public good.